Good morning, everyone. Let me call this meeting to order. It is our public meeting number 39. Members of the public, we are grateful for your participation, for your watching our meeting. The meeting is called to order now. Let me start by asking for a roll call please of our commissioners. Commissioner Bluestone,
I'm present.
Commissioner Calderon,
I'm here. Good morning.
Commissioner Sherry,
Present, good morning.
Commissioner Ellison,
Good morning, present.
Commissioner Kazarosian,
Good morning, everyone. I'm here.
and Commissioner Luma.
Good morning, present.
And at this point, I would ask for a motion to approve the minutes of our June 15th, 2023 meeting.
So moved.
Is
I'll
there a
second.
Thank you. Any questions or comments? Don't think there are. May I then call for a vote? Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes.
Commissioner Sherry,
Yes,
Commissioner Ellison,
Approved.
Commissioner Kazarosian,
Yes.
Commissioner Luma.
Yes, approved.
I also approve. And with that, I turn to our executive director report. Please, Enrique.
Thank you, Madam Chair, and good morning, commissioners. Let me just mention as a housekeeping item, even though that the Q&A function is enabled in our Zoom session this morning, like every other morning, the commission will not be taking questions at this meeting. You can always reach us at 617-701-8401 or by sending an email to poc-comments@mass.gov. I will share my screen in a moment, commissioners, and take you through my presentation for the executive director report. One minute. Can everybody see the screen? Thank you. Okay, so as part of this morning report, I will be touching on the most recent effort of the certification of officers I through P. There are two items for your consideration regarding the dissemination of information. And I'm going to close the section of this report with an administrative update with the help of our CFO, Ravitz. Or I can do the update as well. Okay, so the June 30th deadline for submitting certification information is behind us. I am pleased to report that the process went very smoothly and is working as planned. Post is regularly interacting with agencies via the new portal for this certification, and I will add that this would also be the mechanism to interact with agencies regarding complaints and other incident reports. This includes approximately 700 unique users in the 440 agencies that are within the scope of Post. Like last year, we are on track to certify most of those officers whose information has been submitted because we have a high degree of confidence that they have met the certification requirements of the statute. I want to mention that all of this is possible thanks to the collaboration of the heads of agencies, all of the authorized users, and of course, the ongoing hard work of all of Post staff. I want to provide a brief summary of the process undertaken to date. The development of what we call the permanent solution began soon after the submission for the first round of officers. Those officers A through H had concluded. That was August of 2022. This effort had a lot of coordination with our vendor and everyone within Post who has a role with the system and support functions. The development process hit a major milestone when we deployed the portal on May 22nd of this year, and a lot of effort went in communicating with and training officers and users in anticipation of the date the deadline, the June 30th deadline. This effort of communication and training included 17 separate office hours and training sessions that were well attended. We deployed 9 portal guides with in-depth user-friendly materials. We produced 3 portal training videos, which were uploaded privately to our YouTube channel. These are videos that only authorized users can access. Those training videos, we see that they were received well. Our social media posts are reaching an audience of in excess of 7,500 individual accounts. So the process of building our social media following to communicate is also making important progress. We have received mostly positive feedback and continue to work on improving the user experience. And by that, I mean internal users and external users as well. Our technology vendor continues to be engaged and has moved to implement enhancements to the portal for submitting and complaints and other incident reports. In this slide, I want to provide a brief summary of the information submitted to date. Although the number of agencies that have yet to submit information is seemingly high, it is important to note that several of those agencies may have no officers I through P to submit. I will note that we read data from the MPTC to ascertain the names of individuals who we might expect to be certified. However, the MPTC roster often includes individuals that are non-sworn because they have taken courses with the MPTC, even though they will not be submitting for recertification information. The roster also includes individuals that might be retiring or maybe retired since the last fiscal year, or were supposed to complete the Breach Academy and never signed up. So this is why the number of individuals pending, 557, may eventually be lower than that. As we speak, the team is reaching out to these agencies to ensure that we have all the information for all officers that are required to be certified. So in other words, we are doing a fair amount of cleanup of the database and all of our records as we undertake this process of certification. As I have previously reported, the algorithm, this may be, the algorithm in our technology platform calculates the provisional recertification results based on the answers that to the questions provided. But in the following weeks, the certification team will audit or will really review those answers provided and cross-reference them with information from the MPTC as well as other internal sources. After that review, we will issue certification notices, and our intention is really to minimize something that happened last year, which was the need to issue certain correction letters. We want to, again, minimize or altogether do away with that scenario. So we are analyzing the information submitted prior to sending those notices. As I have previously reported, that our target date is to begin sending those notifications at the end of July. I show some, in this slide, I'm showing some provisional recertification results. And I want to emphasize the notion of provisional here. This is because the review is really ongoing. These numbers only reflect the outcome calculated by the algorithm that I mentioned, but we conduct additional procedures to ensure compliance with the certification requirements. So in the incoming weeks, I will be reporting on the final outcomes of these numbers. Having said that, much like last year, the large majority of individuals would be or appear to be in compliance with all of the requirements of the statute. And what merits our attention and follow-up, and those that follow-up or of those individuals are those small numbers of people that either are slated to be conditionally certified or are requiring further review. I can actually pause here and see if commissioners have any questions or comments.
I just have a couple, if you don't mind.
For sure.
I know last time we were talking about the individual email situation and obtaining emails. Is that process working?
Yes, Commissioner, there's everybody that submits information in our portal successfully means that they either chose one or the other, a physical mailing address or an email address to enter that to enter into the portal. So we have a fair amount of information in that regard. We've talked about at least some instances in which there were concerns. Preliminarily, we can see that the majority of individuals submitted email addresses as the alternative source of information. So that process is working well. Now, it is possible that some of the people that have yet to submit, maybe because they don't have that information, but I don't have firsthand knowledge of that scenario.
Okay, and my final question is on the lagging, the number, the 500 and something that are pending or out there, is
Yep.
that mainly larger departments or is that across the board as far as reporting in with their numbers?
Commissioner, it's actually small departments.
Okay.
It's one or two people from small departments, departments that have 5 or 6 people. And as I mentioned, because we have our roster includes people that are not necessarily sworn or maybe they retired, it could be that that department says there's nobody to submit, they have not submitted. We have a person that maybe we just need an update of that record. For example, somebody who retired in a small department, and we're reaching out to those agencies literally as we speak. That has been an effort of a recent effort because we don't want to let too much time go with somebody not having even information submitted that would render them conditionally certified at least.
Okay, you just anticipated my follow-up was that, is there a time limit on how long we would wait to respond back? So thank you.
Well, on that note, Commissioner, let me also mention there's at least, there were initially 10 and now there's, I believe, 8 agencies that submitted a request for extension. So the numbers that you saw, actually not in addition to the 550 that I reported previously, there's 240 individuals in this slide that belong to agencies that requested an extension. So there's a fair amount of people that are being processed. And, if they're granted an extension, then there's no issues. They can have 30 days, and we suspect that they will that next month all of those will be submitted.
Thank you, sir.
Okay. Okay, I'll move on to the next topic in my report, and that is something relative to the dissemination of information that we will be posting or propose to post to our website. We are these two aspects. There's a memo in your packet that provides a lot more detail. It's summarized in my remarks in the next couple of slides. But we come to you relative to publishing information on decisions that I have made in my review as executive director. By way of background, I will state that when the Division of Certification declines to issue a certification to an officer or places conditions on that certification, which the officer may want to be reconsidered, The officer may seek the review of the executive director. This is something that we have implemented successfully as part of our review process. The decision that I make in that capacity is a written notification, and if there's an adverse decision of the executive director, the commission, the officer can request review by the commission. But for the last round of certification, officers A through H, I have issued several decisions in favor of officers. And as I explained in the memorandum I mentioned in the memo, in the packet, our intention is to soon begin uploading those decisions to our website because these are really public records and they're also matters of public interest. But we come today to you, commissioners, with a proposed process to conduct certain redactions to those decisions. The process that we're proposing would begin by asking the officer or the representative. These are typically cases that involve a lawyer on behalf of the officer to propose redactions to the Office of the General Counsel at post. If the General Counsel or his staff agree with the proposed redactions, they can become effective, and those decisions will then be uploaded to the website with those redactions. And where the General Counsel disagrees with the level of redaction, the Secretary of the Commission could issue a determination. And by the way, if for any reason, which we don't anticipate, the level of redaction brings up a question or a matter of policy, the staff could, of course, then put the matter to be decided by the commission at a commission meeting. The General Counsel has proposed this process, taking elements of other processes accepted in other state agencies relative to matters like this. So I will pause here and see if commissioners have any questions or comments or are comfortable approving this approach to redactions. Commissioner Ellison?
I just want one quick question on where the officer, the opinion isn't favorable for the officer, they have a right to appeal if it was not. Is that same ability available for the appointing authority to appeal to the commission if they feel that the decision was not appropriate?
Yes, Commissioner, and I guess we've had one instance in the past where the head of the agency asked us to reconsider, and that matter went to the Division of Standards for consideration. So there's a mechanism for the heads of agencies, in this regard, but it falls under standards, and then standards would decide as to whether they need to open a preliminary inquiry or gather enough additional information.
So that wouldn't need any review from the commissioners in a case such as that?
It could come up after a couple of steps to the commission. Yes, sir, it could.
Okay. Thank you.
Commissioner Bluestone?
Yes, thank you. I had two questions. I'm not sure if I just followed that last exchange, but so in terms of making the initial request for redactions of the record, it sounds like often these officers are represented by attorneys, but what if they aren't? It sounds like they can individually request a redaction. How will they know that they have that right to have redactions to the record?
Thank you, Commissioner. We would first, before any of these happened, this really would start by us sending this notification to the officer and/or their representative, saying this matter is not yet, this decision. Well, by the way, they already have that. The ones that I'm thinking, they already read the decision. They see that it was in their favor. When we do that going forward, but for everybody else that we have sent beforehand, we would contact them to say, now the commission has approved us to make these records available publicly. They are subject to certain redactions. Please take a look and let us know what you propose. The notice should also include, I would argue, the general topics of matters that are redactable, names of victims, third parties that maybe, where it's not a matter that needs to be disclosed, etc. And they can take that to propose redactions.
And so I would just ask that there be consideration of including the sort of explicit suggestion that they can consult with an attorney about those redactions.
We can certainly do that.
And then just the second question, if I understood correctly, it sounds like if there's a concern about the amount of information being requested to have redacted, what's the process then? How do we review that?
We would then, and if the general counsel's office disagrees with the level of redaction, in other words, they can take that matter to the secretary of the commission, who is, tasked in general with these types of matters, just records that we have to produce as a matter of public records request, for example. If she, Commissioner Casarosian, in that capacity, looks at the level of request that is being redacted, and in her mind, it brings up a matter of policy, something that the commission should weigh in, then we would come back to the commission to address that matter of policy. But this is a very small probability scenario. But in the first instance, she would apply the criteria for redactions, and she would either agree or disagree, and we would go back and notify the officer or the representative, and have that discussion.
And would there be an additional option for review by the commission if they questioned that decision?
We can certainly do that. Yeah, we could certainly note if somebody, I don't know, objects as a matter of principle and wants that reconsideration, we could certainly bring it back to the commission.
I think I would personally suggest that, since that seems to be generally the level of the way that these sort of appeals go in most other instances.
We could certainly implement that. Any other comments or questions on the topic, commissioners? Okay. Let me go back to the next matter, which is also a matter of dissemination of information, also including the same memo that I referenced earlier, and that is information that pertains to conditionally certified individuals. To date, Post has not published officers with the status of conditionally certified. We are now proposing to publish these individuals, provided that certain parameters have been met. Those parameters include that the Division of Certification must have some reasonable confirmation that the individual officer has received notice. That also that the officer is not challenging the decision, and that at least 21 days have passed since that proper notice. And the reason for these topics, or these parameters, if you will, is that while an officer is challenging a decision, then those matters are not yet public. So we want to get comfort level that they've been properly notified and they are not, in fact, challenging that decision. I will note that the key parameter in question, of course, is confirmation whether the officer is challenging the decision or not. So in light of these, the 21 days that the regulations provide for a minimum number of days to have passed could be set by policy at a much larger time. It could be 6 months, it could be less, it would be whatever the commission might be comfortable establishing. I will pause here again and ask if commissioners, if there's any questions or comments as to whether the commission is comfortable following this approach. Yes, Commissioner Luma.
Are these primarily officers who may be on leave or who haven't completed trainings?
These are primarily officers who have not completed the work requirement of the Breach Academy, Commissioner. So,
Okay.
and that work requirement has an outer date of 2027, I believe. So, you know, we wouldn't wait until then to publish them. I think they merit to be published as conditionally certified. By the way, it's not clear from the slide, but we don't propose to publish the conditions. We will just publish the status of conditionally certified. But the reality is that mostly are work requirements around the Breach Academy.
Thank you.
Other questions on this topic or? Madam Chair, I had drafted the memorandum with the recommendation to take up as a vote. I can also just, if there's no objections, continue with this or pause to see if other commissioners have other questions about these two topics, the dissemination of information of conditionally certified officers and previous executive director review decisions.
And specifically, what are you asking the commission to vote on?
So on the proposed approach, on the first instance, whether they are in agreement with the proposed approach for implementing redactions, that we send the officer and the representative the opportunity to propose redactions. The legal department looks at them. If they disagree, they bring it to the secretary. And as Commissioner Bluestone suggested, where there's disagreement, we could bring it back to the commission after, at the very first beginning, notifying the officer that they can have legal representation to propose these redactions.
And just to make certain, did I hear you say subject to the suggestions that Commissioner Bluestone made in terms of additional information?
Correct.
Okay. And you'd like us to take a vote on that?
Yes, please.
Approve that procedure as outlined by you?
Yes, please.
All right. Commissioner Bluestone?
Yes, I approve.
Commissioner Calderon?
Yes, I approve.
Mr. Sherry?
Yes.
Mr. Ellison?
Yes.
Mr. Kazarosian?
Yes,
Mr. Luma? Commissioner Luma?
I see her screen is black. Oh, she's saying yes, but you were on mute, Commissioner.
Okay, and I also approve, so that's unanimously approved. And then in addition, you'd like us to approve, Enrique?
Yes, approve the conditionally certified disclosure, the disclosure of or publishing of conditionally certified officers. And after some period has passed, whatever the commission is comfortable with. I'm suggesting more than 21 days, which is what the regulations propose. But if you're comfortable with 6 months or anything else, we can implement that. The notion being that some time should pass so that officers have an opportunity to challenge the decision made by the Division of Certification or the Executive Director.
Well,
So,
sorry, I think.
I'm sorry, apologize, Sandra. I just wanted to be clear that if we're going to vote on it, I would be comfortable if we had a number of the days, only because then it would be subject to interpretation. So if we put one out there, if there needed to be an extension, I would be okay with that. But just that for the record that we had a number of days that we were using as a standard.
And what would you recommend as the number of days, Commissioner Ellison?
I think 30 days would be, in my opinion, 30 to 45 days. And if an extension, then the person can request one.
And
After that.
Are you specifically saying 30 days have passed?
Yes,
And you're suggesting that we would approve that?
yes.
Any other
With that
comments?
number.
Thank you. Sorry.
Mhm.
Any other comments from the commissioners on that period of time? Yes, Commissioner Bluestone, please.
Not so much specifically on the period of time, but just how the notice is provided to officers of their right to challenge the decision. How is that? I'm just curious. I don't know exactly how that, I'm assuming that that's in the information that they receive, the notification that they receive, that they can challenge it. Is that correct?
Yes, Commissioner, every notice that we send, I would have to check, but maybe with the exception of full certification, every notice we send, we stipulate all the recourse that officers have to challenge, anything.
Any other questions or comments? If not, then let me ask for, as Enrique has requested, approval of what he set forth in terms of the conditionally certified individuals, but as modified by Commissioner Ellison, 30 days has passed rather than at least 21 days. Commissioner Bluestone, do you approve?
I approve.
Commissioner Calderon,
Yes, I approve.
Commissioner Sherry,
Yes.
Commissioner Ellison,
Yes,
Commissioner Kazarosian,
Yes,
Commissioner Luma.
He was
It-
having technical difficulties, but she says yes. I'm sorry, I can see her screen.
Thank you. And I also approve. So that also is unanimously approved.
Thank you, commissioners. I will close with this part of the report with mentioning that we're working to release officer information in a more streamlined version from the reports we currently have. We're envisioning a report where we could have all officers listed alphabetically and by agency and with any of the certification status. Certified, conditionally certified, not certified, or under review as our regulations provide. This report would be by last name and also by agency. And the disciplinary records database will be a separate database. I want to mention that post staff spends a fair amount of time and effort updating these records, given the large nature of these data sets. I also want to mention that we have been made aware of a couple of sources that include officers' records that may have been labeled post records. And I want to be clear that the only source of legitimate information should be construed to be our website, because we update and continue to update that information on an ongoing basis. Let me pause there and see if Eric is around, a panelist. If not, I can take, I don't know, I didn't see him as a panelist. Is Eric available? I'll just go through the administrative update. It's really brief. We want to welcome new hires, Matt Wardle and Beth Wilson, two compliance agents that recently joined the Division of Standards. Bob Wong, who joined us this Monday as a budget and finance operations manager. We have 3 legal interns this summer. Their names are Ben Albert, Jason Lee, and Nick Santiago. They're helping out the legal department in a lot of the work that they need to do. We will be onboarding the 3rd enforcement counsel for the end of July. We are wrapping up 2 data analysts positions that are going to come and help, one in the certification unit and another one in the IT department. to help with all of the information, ad hoc reporting, and public records request answers that we have on an ongoing basis with all of the information that we manage. And we have posted for a second intake coordinator to look at complaints, specifically the ones that come from agencies, and an enforcement counsel number 4 to continue with the workload of the Division of Standards. There's two additional legal staff, and we are working that will come under the Office of the General Counsel, and we are working on posting just those job descriptions soon. I'll also report, commissioners, that we are, within weeks of moving to new offices. We'll be executing a lease for permanent headquarters in downtown Boston. We're taking space that is very suitable to our both size and needs, and that will include space to conduct public meetings and hearings in person where we found those to be necessary. Our target moving is late August, so I will be coming back to the commission with updates and perhaps one meeting in the near future from the meeting in that space. That concludes the portion of my report, commissioners. I can take questions if there's any. Yes, Commissioner Allison.
Just one quick question on the budget there. I know I've been getting the regular updates from Eric and yourself, and I appreciate keeping up informed. Has the final vote, the budget, or such as the budget for 2024, been approved for the Post Commission and the amount that we were looking at?
We have a high comfort level that it'll be the way we looked at it, because there's both the version of the House and the Senate are identical, and that means they're not subject to reconciliation. As I understand, the governor has not yet signed the final version for the Commonwealth's budget, but it's imminent. We can report on that next commission meeting, Commissioner.
Thank you.
Commissioner Bluestone.
I wanted to just say that it may seem a little anticlimactic, but I want to recognize what a tremendous amount of work and effort it has taken to get the certification status to the point where the data is reliable enough to publish it. And I just wanted to express my thanks to everybody who's worked on that. I understand that's a huge project.
Thank you, Commissioner. There's a lot of back and forth that goes with communicating with agencies. We have a very large number of people that we have to make sure that we have the right information. The NPTC spends a fair amount of time as well trying to clean up their own data, and we have an intersection of that data. But yeah, we have a fair amount of people ongoing looking at and showing that the data is correct. Okay, seeing no more questions or comments. That concludes my report, Madam Chair.
Thank you very much, Enrique, and I would only echo Commissioner Bluestone's comments and thank the staff for all of their hard work that has led to the report that you just provided to the public. Let me then move on and turn to the director of our Division of Standards for an update, please.
Good morning, Madam Chair. Thank you. Good morning, commissioners. And I think the two slides that I had are on the same presentation that was just on the screen. So I can put it up, or if
I'll put it up.
Okay. Yeah, thank you. Okay. So good morning, commissioners. I'm grateful for the opportunity to provide you an update on the Division of Police Standards work over the last few months, particularly with respect to citizen complaints and preliminary inquiries. So as you can see on the screen, since May 1st, we've received an estimated total of 162 complaints, and these have been submitted directly to the commission by members of the public, and that's whether through the commission's website or other means such as, the occasional email or phone call that we've received. We've also received a number of complaints prior to May 1st, But I'm not providing a number at this point because there's still some deduplication that needs to occur on those complaints and some additional review that needs to happen before I could give you a number with, I think, sufficient reliability. So we're working our way through that right now. And that is all taking place in the context of our growing team's capacity, and also I think some important enhancements to our computer and IT systems that I think will allow us to complete that work expeditiously. So for those curious, the division intakes approximately 15 to 20 new complaints every week. That's a rough number, but it seems to be what we're seeing. Our process generally is that we review these complaints promptly, and most of them call for at least an initial referral to the law enforcement agency that is, I think, mentioned or implicated by the complaint. We will make these referrals either to have the agency commence an internal affairs investigation when there is a credible allegation of misconduct, or in cases where the complaint isn't fully clear what the complainant is saying, but it does seem clear that some kind of police interaction happened. We will ask the department to provide us any context that it might have as to what that interaction was. And all of that has proven very helpful, and it's allowed us to either follow up on or resolve a number of these complaints in what I would say is a fairly efficient manner. At the same time as we receive complaints from the members of the public directly, we are also receiving complaints and other information from the law enforcement agencies themselves. And you see the number 974. That reflects really all kinds of communications that the division receives from agencies. And that can include things like complaints that citizens filed with the agency, which the agency is then required to pass along to the commission pursuant to the commission's regulations. That number also includes information relative to agency-led internal affairs reports, whether it's the report itself or even just communications related to the reports, such as communications that the agency intends to commence an investigation or a status update or things like that. And there are other kinds of communications that we receive, just status updates and things of that nature. So that 974 number really encompasses all of that. And as with the civilian complaints, we do have a pretty steady flow of notices or communications from the agencies to the tune of, again, approximately 25 per week. So that summarizes really how the volume that we are seeing with respect to complaints and other types of notices from agencies. And I think, as the executive director mentioned in a prior slide, we are really standing up the division's functions to be able to process and respond to all of these matters. As we indicated, we added 2 new compliance agents in the last several weeks. That has doubled our investigative capacity. We'll soon be joined by a 3rd enforcement counsel. We're currently seeking to hire a 4th, and that's going to double our capacity in this respect as well. We hired an intake coordinator recently, and that person has done a wonderful job at managing and providing some initial triage on the complaints that we have been receiving since May 1st, and we're seeking to hire a 2nd person to supplement and expand on that function. So we're doing all that work to be able to support the division's mandate under the statute. And we think that although a lot more work remains to be done, we've made a lot of progress in the last several months. We're proud of that progress. The team has worked very hard, and we're looking forward to providing further updates in the months ahead as to this information. If we can go to the next slide. So this slide contains an update as to our current caseload, and that as of July 5th. But as you can see on the slide, there are currently a total of 35 individuals whose certification is actively suspended. And that information is published on the commission's website. We update that at the beginning of every month. And that reflects, I think, entirely reflects officers that have had their certification suspended because they've been arrested or charged with a felony offense. As to our preliminary inquiries, we've also begun presenting the results of our preliminary inquiries to the commission during executive session. and I am limited in what I can say on this topic in this forum due to the police reform laws, strict confidentiality requirements governing such matters. But I am able to say that the division currently has open inquiries as to 38 individual officers, and that and we also will at today's executive session be requesting authorization to open an additional 6 inquiries, which would bring us to a total of 44. The division, we take each case incredibly seriously, and we approach the case really in a very careful way, and I think reflects the hard work and the attention that we're paying to the cases and trying to balance the factors that are at issue, both with respect to the public's rights and also to the officers' rights and the interests of the profession as well. And the final number there is an indication that as to 14 matters, the division has recommended and that discipline be imposed pursuant to the commission's statute. And each of those 14 cases really are at sort of varying stages of the adjudicatory hearing process. With respect to that, we will continue our work in those matters. We look forward to sharing future updates. And I would, at this point, pause for any questions that any of the commissioners might have before I turn it back over to the executive director. Oh, Commissioner Ellison.
Yeah, I thank you for that report. I have a couple of questions for you. So one, a comment. It seems as though that the reporting from police agencies seems to be working in the way it was designed, where it sounds like you're getting those in a timely manner to be able to cross-reference if that report came into the police department as well as to the post.
It has worked. I think it's going to work even better with the launch of the law enforcement portal, and that's going to allow the officer or the agencies to provide that information in a system where we can actually assign data fields and track deadlines and things. I think in a more systematic way than that has existed, when the division first began its work. So yes, it has worked. It is working. I think it's going to work even better as the portal begins to come online.
And my second is when these come in, and I know each case is different, on average, how long is it taking to get back to the complainant with some response as to what, if anything, is being done with their complaint?
It definitely varies. I would say with respect to the complaints that in that May 1st period that I mentioned in my first slide, we are sharing most of those with the agency in question. And it really depends on how much work needs to be done. If the agency is got things already done, things to send us, we're able to vet it and respond more quickly. In other times, it just takes longer. But we do have a goal of following up with each complainant to advise them as to whether action will be taken or follow-up will be advised or some other follow-up. We do have a goal of responding to those complainants.
And then just one quick follow-up to that. And so do they receive an acknowledgement in a timely manner? I'm assuming that you have received this complaint. Is there something that's sent out to them, or is that communicated through an individual that the complaint has been received and it's been investigated?
If they, yes, they do receive that. If they file their complaint through the commission's website, that's policecomplaints.mass.gov. They get an immediate email confirmation back that states to them that their complaint's been successfully received. They get a tracking number on that. And then again, once we've done our work on it, we also have a goal of providing, affirmative feedback stating that, this is what happened with that complaint.
Thank you.
You're welcome. All right. Thank you very much.
Madam Chair, I have one item to talk about as part of the Division of Standards update, if I may.
Yes, of course.
I just wanted to mention, just give you a brief update on a recent issue that has been reported publicly, and I'm referring to the integrity of the exam at 2 academies of the MPTC. The MPTC recently informed us that several student officers in 2 of their academies compromised the integrity of the testing procedures and the testing materials. This was actually a violation of the MPTC honor code and academy policies and possibly prohibited conduct under Chapter 6E. So the MPTC began an initial investigation. They found that 4 student officers were in some level of violation of either the policy and or the honor code, and the MPTC have taken steps to discipline those 4 student officers. And I will mention that that discipline may have included the dismissal from the academy. The MPTC is also in the process of retaining an independent investigator to conduct a comprehensive review of the matter. They have communicated with us, with the Division of Standards, and they will continue to do that to ensure collaboration. And as the Commission knows, hosts can receive complaints from any source, and if and when the Division of Standards finds sufficient credible evidence that an officer engaged in prohibited conduct, they may come to the Commission for approval to open a preliminary inquiry. I will note that the passing that exam is also a requirement for certification. So I will mention that as per Section 10 of Chapter 6E, if the certification of an officer is obtained through misrepresentation or fraud, or an officer falsifies a document to obtain certification, either instance constitutes prohibited conduct under the statute and therefore subject to the revocation of certification. I will close by stating that if and when we encounter a situation that would merit opening a preliminary inquiry, we will come to the Commission for approval, and all of those proceedings at that point and going forward will be confidential. I can answer any questions if commissioners may have at this time. Commissioner Allison?
Yes, Enrique, in that matter that you just discussed, will they be sending a follow-up, the MPTC, as to what the outcome for our review on something as important as that?
Yes, they are in the process. I may have said this quickly, but they're in the process of engaging an outside investigator. They want to do a comprehensive review to really ascertain the level or depth, or how far this may have gone on. They only have evidence at this point of 4 student officers who have been disciplined. We want to make sure that there's there were no other people involved in the matter.
When you say discipline, I'm just curious, what is the current status? Are they still attending, or are they still in the class? I mean, it seems that this is something that would rise to the level of, at some point, maybe termination, but I'm just wondering if the discipline included them being temporarily suspended from the class.
I think it's all of the above, Commissioner, and I'm not sure I could share any more details other than that there were different levels of discipline because there was different level of cooperation with that initial assessment. But some of the levels of discipline included dismissal from the academies. So
no, I mean, it's quite concerning. That's something of that magnitude at the beginning of your career.
Yes, for sure. And which is, again, the matter has been reported publicly, but I wanted to address it as to the role that we play in collaboration with the MPTC, and that's where things stand.
Thank you.
Commissioner Bluestone?
I'm just curious about kind of the lines of oversight or authority, and wondering about whether these might be cases where we would do a preliminary inquiry as well, or if they are excluded from that by virtue of not yet being certified as officers.
Yeah, that's an excellent question, Commissioner. I cannot, I do not have information to really ascertain whether the current, the 4 student officers were technically under our purview or only the MPTC. I guess what I'm suggesting as part of the investigation is we want to ascertain whether there's other people in addition to those officers who may include existing officers. And those are definitely under our purview. And that's why if and when we get in a situation like that, we would come to you to ask for approval of a preliminary inquiry. Like we always do, we have to first ascertain sufficient credible evidence. And that's, I guess, what would be the next step.
And I think a secondary issue I would just raise as a question is that given that the allegations here have to do with officers in training, and I do understand that there's an independent investigation being started, but it does seem like this is a case where, as a separate agency, we may want to consider what our role is in the event that there are any conflicts of interest or any systemic issues that might be related to this.
Yes, very much so. And we'll give that great level of consideration with Director Landry and General Counsel Ravitz and outside counsel where we need to make sure we're not, let's say, compromising that investigation by being overly involved. We have, unlike that investigator, by the way, whoever they hire, we will have subpoena power, and we want to preserve, the integrity of all of that, and everything that comes after it. So very much in consideration, Commissioner.
Thank you.
And I think unless there are any additional questions, let me thank you, Enrique, for your very comprehensive report, and thank Matt as well for his report, and thank all the members of the staff who have done the work which has led to the information that's been provided to us by the two of you. And with that, let me turn next to our General Counsel's legal update. Randy, please.
Thank you very much. I will attempt to share my screen. Okay. Hopefully people can see this PowerPoint.
Yes.
Thank you. This concerns 2 sets of regulations that have been making their way through the promulgation process. And the first one is 555 CMR 11, which concerns regulatory action and advisory opinions. Just to provide a recap of the promulgation process and where we are now. These regulations, as the commissioners will recall, were previously approved by the commission, and they would satisfy the statutory requirement to promulgate regulations concerning petitions from members of the public for regulatory action by the agency, and also prescribe procedures for the exercise of the statutory power to issue an advisory ruling, or the term used in the regulations, an advisory opinion. And so they address matters such as procedures for hearings on regulations and the approval and publication of advisory opinions and the effect of such opinions, and how both types of documents can be revised, and associated administrative steps. These were the subject of the hearing that was held on June 6th, along with another set of regulations that we'll be talking about next. But as to these regulations, there was no feedback provided either at the hearing or through written comments. And so we're resubmitting these to the commission without any changes made since the last time they were approved. And we're asking that they be approved for final promulgation. So if there are any questions from the commissioners and the chair would like me to answer them, I can answer them. Otherwise, we would ask for a vote on these regulations again, which have not been changed.
I don't think I see any anybody with any questions or comments, so let me ask for a vote. Commissioner Bluestone,
I approve.
Commissioner Calderon,
I approve.
Commissioner Shuri,
Yes.
Commissioner Ellison, please.
Yes.
Mr. Kazarosian,
Yes.
Mr. Luma.
Yes.
I also approve. They're unanimously approved. Thank you.
Thank you very much. The next set of regulations is 555 CMR 9. And that set of regulations concerns the initial certification of officers and the renewed certification of independently applying officers. And I'll just provide a review of the promulgation process regarding this set. The version that was previously approved by the commission covered, again, the initial certification of all officers and the recertification of independently applying, or as we sometimes call it, self-sponsored officers, including constables. Now, as I'll explain in a minute, the provisions regarding constables have been removed from the version that you now have, but I thought it would be helpful just to provide a recap of the aspects that were specific to constables in the original version, because it did seem from the hearing that some further clarification might be helpful, that there may have been some misunderstanding from people who offered comments. That set of regulations had provided that if a constable executes an arrest or obtains certification, the person then becomes subject to regulation like other officers. And the regulations were designed to provide for constables to be subject to a regulatory scheme that would be comparable to that provided for other officers. And they provided that one who is subject to regulation can only execute arrests or otherwise perform police duties and functions with a certification that allows for it. So in other words, they provided that the execution of an arrest without certification would simultaneously subject that individual to the regulatory scheme and place them in violation of it. Again, if they execute an arrest without certification. It also sought to ensure that a regulated constable would be subject to supervision comparable to that provided to other officers in law enforcement agencies. And it required one who is seeking certification to provide assurances regarding that supervision, that will be provided. However, that set of regulations did not subject a constable to regulation if the constable did not execute arrests or obtain certification, and it did not preclude or subject constables to any regulation for the mere service of papers without more. So again, that's just by way of clarification regarding those provisions. Now, at the June 6th public hearing and through written comments, the commission received feedback only with respect to the impact that the regulations would have on constables. And there were a lot of comments on that subject. There was, however, no feedback about the general processes for initial certification and recertification of self-sponsored individuals. That is, as they relate to individuals other than constables. So taking into account the public feedback, these regulations have been now resubmitted to the commission with changes in redlining, and it's requested that they be approved for final promulgation. But I'll go over the changes that were made since the public hearing. So in light of all the comments that were received, the provisions that were specific to constables have been removed for now. And the certification of constables and issues regarding their powers, duties, limitations, and supervision would then continue to be worked on and discussed. But in the meantime, the remaining provisions regarding initial and self-sponsored certifications have remained. And they now provide that a certification that's awarded pursuant to these regulations could be used only for service in a law enforcement agency where there will be supervision. So again, the provisions regarding constables have essentially been put aside for now, and the rest of it would remain, and the focus of the regulations would be on certification of people who will be working in a law enforcement agency. Now, at the same time, the regulations do regroup certain concepts regarding arrests and the performance of police duties and functions, and make clear that those concepts would apply to all officers, whether they serve in law enforcement agencies or are constables serving independently. So I'll just talk about those reconfigured provisions. One is found in section 910(5)(a), and it now provides that a conditionally recertified officer can continue serving without being required to satisfy any conditions during such time as the officer still has the ability to challenge those conditions, but provided that the officer is serving in a law enforcement agency. So that there was a provision along those lines that was already in there, and there's a provision along those lines that's in the recertification regulations. But the change that was made was just to cabin this provision in the new set to an officer who is serving in a law enforcement agency where they will have supervision. Then section 913(2) was revised so that it now provides that a new certification period does not start before the applicant begins serving in a law enforcement agency. So there too, there was a comparable provision in the earlier set, but now it's been cabined to in such a way that a certification period doesn't start before the person begins in a law enforcement agency. And then there's a new subsection 913(7), and that provides that a certification awarded under these regulations will be active only during such time as the individual is serving in a law enforcement agency. So that, again, that reflects the change in focus of these regulations. And if there are any questions and the chair would like me to entertain them, I can do so.
I have a question, Randy, if you don't mind.
Yes, please.
So on the constable issue, I know because I was on that meeting and it seems somehow they were looking for a carve out of police powers without having to go through the training that everyone else who has the authority that police do to be able to do that job. I'm just trying to figure out how, even going forward, that would be possible to have an exception that they're looking for to be able to perform their duties with arrest powers.
Well, the way that these regulations are now structured, and I do have, by the way, another section that provides guidance to constables if these regulations are adopted. But the way that these are now structured, an individual who is a constable could seek enrollment in an academy and satisfy the same requirements that any other individual would need to satisfy in order to get certification, but they could only use a certification under these regulations to work in a law enforcement agency. They couldn't use it to work as a constable, at least not yet, because the issues regarding supervision have not been addressed. So that individual would be working and exercising powers without the kind of reporting and oversight that's normally provided to law enforcement officers. So that's why that's been put aside. But these would also provide that an individual could not execute arrests or perform police duties and functions without being certified.
So I guess a quick follow-up to Randy. So a constable who falls under A through H, who's already been certified by the commission, would be now governed with, it had police powers. That person would now be under the same review of a police officer, because they've already, if their name fell into that A through H that we've already certified and you're a constable.
I'm sorry, Commissioner, I think you got cut off at one point.
Randy, I think Commissioner Ellison is frozen, but I think I got the gist of his question. If we want to wait till he comes back, or?
Well, if I can say what I understand right now, which is that if somebody was in the A through H group, they would have been automatically certified if they satisfied the requirements in the session law, which included completion of basic training. So for a lot of constables, that would not have been the case. They would not have gotten that automatic certification. If they did fall within that group, and they were recertified, and I'm not even sure that there is anyone like that, but you know, if that were to be the case, or if that were to be the case with somebody in I through P, and they got fully recertified, they met all the requirements, then they could execute arrests as a constable. But these regulations would provide that if somebody is not certified, but they're executing arrests, then they're bringing themselves within the scope of chapter 6E, because they're a constable performing an arrest, and yet at the same time they would be violating these regulations because they're executing an arrest without being certified. Is that clear?
And I think Commissioner Bluestone has a question as well.
Yeah, thank you, Attorney Ravitz. I think that the kind of the sticking point I'm having here with this is that, based on the commentary that I heard at our open meeting, it sounds like really a lot of the constables don't initiate arrests, and yet it's a power that they sort of have as kind of that they can access in an emergency situation, as I understand it. And so my concern is that they would now be in this nebulous status where they could say that I'm going to not go forward with satisfying the requirements for certification because I don't do arrests, but then could find themselves in a situation where they needed to initiate an arrest and would then be in violation of the policy. And so I'm wondering if there should be some sort of temporary status to sort of give them time, because I could see a situation where that could compromise their ability to respond to a situation. And yet they may not anticipate that.
Well, something could be developed, but really this was written on the idea that if somebody has not received all the training that's afforded to law enforcement officers and they haven't satisfied all the criteria, that really they should be performing their duties in such a way that where they would not end up making arrests. So that, for example, they would be performing much like somebody who is a civilian working for a law enforcement agency, who might further the goals of the law enforcement agency, but would not be exercising arrests or exercising police duties and functions. By the way, just getting back to Commissioner Ellison's question, that really the provision that I had in mind was this new provision that would state that the following individuals, and it's subsection 8, may not execute any type of arrest, as that term is defined, or otherwise perform police duties and functions. So the first category is an individual who's serving as a law enforcement officer, as defined in the statute, any type of law enforcement officer. However, when it comes to constables, that's a constable executing an arrest. That's who would satisfy that definition. But as soon as that person becomes in scope for purposes of Chapter 6E, then they would be subject to this provision. So they cannot execute an arrest or perform police duties and functions if they're not certified under subsection A. And then the others are things that we've discussed before. If a person has a certification that's suspended or it's been revoked, or if there's some limitation that prevents them from engaging in a certain form of activity, or if they lack the legal authority to engage in that form of activity, they would not be able to execute arrests or perform police duties and functions.
And Randy, if we could, at this point in time, just turn to our outside counsel, who I think will simply add a bit to what has been discussed and to the question that's been raised. Lon?
Thank you, Chair Hinkle. No, I agree completely with what Randy said. And, you know, this issue with constables has really been before the commission since the very beginning. I mean, Enrique and I met with constables several years ago on this, and the issue, respectfully to the constables, that they have with the post commission derives from the statute that Randy just referenced, really, because the definition of law enforcement officer does include constables who execute arrests. I would editorialize that makes sense because they're exercising police powers at that point. But the legislature has decided, or did decide when it passed the statute that created the commission, that constables who execute arrests should be trained and treated and certified just like more typical law enforcement officers, you know, who serve in the law enforcement agencies in the Commonwealth. So the dissatisfaction that constables continue to have with the valiant efforts of the commission to thread this needle have in their origin the statutory language in the passed by the legislature. And you know, that may be a place where, if they are trying to get a different result from the ones that have been proposed by post, that they could look, because that's obviously cabins and restricts the degrees of freedom that the commission has to create regulations that implement the statute. So I just wanted to, again, I agree with everything that Randy's presented and all the changes and all the efforts that have been made to develop regulations that seek to follow the statute and are acceptable to the folks who advocate on behalf of constables. But it really all goes back to Chapter 60.
Thank you, Lon. And I think Enrique has had his hand in the air for a while. Let me turn to him and then Commissioner Ellison, you please.
Okay, thank you, Madam Chair. Just to reiterate something that Randy mentioned, but was not 100% sure. I am pretty sure that no constable has been certified under A through H or I through P, as this matter has been pending, unless they went to a full-time academy and were part of, you know, met those requirements that other way.
Thank you, Commissioner Ellison.
Yes, sorry about the technical difficulty. So I guess my question is that how is a constable different than special police who've lost their arrest powers because they weren't properly trained? They're still operating as special police for whatever company they may work for, but they don't have police powers. I'm trying to figure out how a constable will be much different than that individual who no longer has police powers, that hasn't completed the required training.
Well, if the constable is executing arrests and would want the ability to execute arrests as part of their activity, that's what would move them from one category to another, from the category where that's shared with civilian employees of a law enforcement agency into the category that's shared with other law enforcement officers, where they would be expected to not only to satisfy all the requirements of certification, but to also satisfy all the requirements going forward of being an officer. Does that Does that answer the question?
It does. I guess my concern is that if someone who's a constable who has been made an arrest today, would that be a valid arrest, and would that be something that would come to the post for review?
If they made an arrest today, and they were not certified, they would, under 6E, without question, they'd be bringing themselves within the scope of the statutory scheme. So now they would be an officer for purposes of the statute, and they would be an uncertified officer. And under these regulations, it would make clear that that the moment that they performed their arrest, they not only brought themselves within the scope of the statute, but because they did it without being certified, they violated the commission's regulations. So it would leave no doubt that the commission could then take some appropriate action. Now, does that answer the question, or was there?
It does. It does. Thank you. That's why I just wanted some clarification on. Thank you.
And I think Commissioner Bluestone also has a question, please.
Yes, I just wanted to follow up on that, because am I correct that initially officers were essentially grandfathered in as certified during the period that the procedures for certification were being developed? And it seems to me that, that scenario that Commissioner Ellison describes is a concerning one, because the constable could be in a position, because I think it really, from my impression, it sort of varies very much across the state how constables are utilized, that the constable could be in a position of needing to execute an arrest and would then be in violation of policy. And I'm wondering if that is something we should consider in light of the fact that they've not had the opportunity yet to pursue a certification.
And just a quick follow-up to that, because some of them on that June 6th call felt they were elected, that they didn't fall under the standards because they were elected and not appointed to their position. So there was some confusion to that as well.
Commissioner Keserosian. You're muted.
Yeah, sorry. And I'm actually interested in hearing the response to what Commissioner Bluestone just raised. But my other concern about it, maybe I'm wrong, is if a constable does make an arrest and they are not certified for whatever reason to do that, to act as law enforcement, that's also going to that's also going to impact the legitimacy of the arrest, I would imagine, and cause a whole slew of other issues that I think we have to think about. But I also am not sure why we would be carving out something for constables that we have not. They have the same opportunities as any other person seeking to act as a law enforcement officer as other law enforcement officers, as I understand it. And to have carve out specifically for constables for certain circumstances, I think becomes pretty problematic. I'm not sure it would even be equitable, but that's just an observation.
And let me just ask at this point, Randy, what are you expecting that we will do today with what you have been spending time on the last period?
Well, what I was hoping was that the commission would take a vote on this set of regulations, which again, now just provides a path, excuse me, a path for someone who is right out of the academy and needs that initial certification to get that certification, or for somebody who is either is working in a law enforcement agency or is planning to work in a law enforcement agency and who is seeking recertification, but for whatever reason is not endorsed by an agency, or at least not yet, and wants to pursue certification on their own. It provides a path for that person to get certification, and it just puts aside the path for certification of constables for the time being, while all this that we've been talking about can be explored further.
Thank you. So let me ask for a vote. Commissioner Bluestone?
Sorry, no.
I'm sorry.
I vote
Did you say-
no.
Thank you. Sorry, I didn't hear you. Commissioner Calderon,
I vote yes.
Commissioner Sherry,
Yes.
I'm sorry, maybe my audio. Did you say yes?
Yes.
Thank you. Commissioner Ellison,
Yes.
Commissioner Kazarosian,
Yes.
Mr. Luma,
Yes.
and I also vote yes. So that is approved. Anything else, Randy, to address today?
I could provide something of a recap of guidance for constables now that this has been approved. So in other words, what it means and doesn't mean for them, or depending upon things like the time that we have today, that could be put into some sort of a separate document that we make available.
Well, I think it would be, given the nature of the discussion that has been had over the last months, it would be useful to have some sort of document. Do the rest of the commissioners agree?
Mhm.
Yes, I think so. So, Commissioner Luma, please.
Yeah, Randy, I believe in the last meeting, it was mentioned that there was a request by the Massachusetts Association of Constables. I don't know if that's the correct title for that organization, to consult with them about these regulations. Do you know if that's happened?
Well, it's been happening over time.
Okay,
As far as these latest round of revisions, we didn't engage in another round of consultation with them, really, because these are designed to, again, put aside the issues regarding constables. But we do look forward to talking with them further.
thank you.
Thank you.
Any other questions or comments? Yes, Commissioner Bluestone.
I just want to reiterate that my concern is really just this sort of immediate period of time where they're in this gray area and have not been afforded potentially ample time to make a decision about how they proceed. And then the secondary issue being that if they go forward with certification, that then it sounds like they need to fall under the purview of a law enforcement agency, which is one of the issues that they express concern about, given their independence. So those would be the two things that I would just ask us to think about.
Thank you. Anybody else? Any of the other commissioners? Any other questions or comments on this issue? Let me thank Randy very much for all the hard work you and the other members of the legal staff have done with regard to the issues that we have addressed today. And I think with that, let me move on to the next item on the agenda. Number 6, matters not anticipated by the chair at the time of posting. There are none. And therefore, I would move on to indicate that we will go into executive session in accordance with General Laws, Chapter 38, Section 21A5, in anticipation of discussion regarding investigation of charges of criminal misconduct, and under the same statute, but Section 21A7, combined with Chapter 6A, Section 8C2, and to the extent that they may be applicable, General Laws, Chapter 6, Sections 168 and 178, in anticipation of discussion regarding initiation of preliminary inquiries and initial staff review relating to the same, and regarding certain criminal offender record information, and General Laws, Chapter 38, Section 21A7, also combined with Sections 22F and G, in anticipation of discussion and approval of the minutes of prior executive sessions. Let me indicate that to members of the public that we will not be coming back after the executive session to the open meeting. And I think with that, do I have a motion to go into executive session?
So moved.
Is there a
I'll
second?
second it.
Thank you.
Mhm.
Thank you, Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes.
Commissioner Sherry,
Yes.
Commissioner Ellison,
Yes.
Commissioner Kajirosian,
Yes.
Commissioner Luma,
Yes.
I also approve. And again, let me thank the members of the public for their attendance, and let me thank all of the members of the post commission staff for the extraordinary work that they have done on behalf of our obligations under the statute. And I think with that, we will. I'm sorry, I guess I need a motion now. Randy, do I need to move?
You did it. It's all set. You're all set.
All right, thank you. Commissioners, we will reconvene. Let's take approximately 7.5 minutes and we'll reconvene. I know that we're a little late in starting this meeting. Thank you.